Back in conversation with the immigration attorneys of the NPZ Law Group, serving employers and immigrants throughout the United States, Canada, and around the world. So, Lutka, let's talk about the CSPA, or the Child Status Protection Act, which seeks to protect children who are aging out due to the large USCIS processing backlogs. Am I right?
Yeah, that's absolutely correct. So this was enacted in 2002. And this is very important protection, especially for our Indian clients. I have to say, majority of CSPA calculations I do for our Indian clients.
Oh, okay.
And why? Perfect example is a F4 preference category. So this is a US citizen brother or sister petitioning for somebody in India, correct?
Yeah.
They may have family, kids. The kids are 10 years old, for example. But the wait time is right now about 15, 16, 17 years to get a green card. So by that time, when the priority date becomes current, these are not kids anymore, but these could be individuals that are 25 years old and so on. So we call it that they age out. And that's a problem. That's why we have CSPA. CSPA is a method to calculate the age to see if the person qualifies for a child. Child under immigration law must be under 21. So it's not 18, it's under 21 and unmarried. So oftentimes I do have clients that have kids that now they may be, let's say, 22 years old, 25 years old, but they do qualify under CSPA based on the qualification, the method that we are going to be using. And here, the most important is to remember how long the I-130 petition was pending. So if the petition was pending, for example, for 5 years, we can actually subtract all these years from the applicant's age.
Oh, cool.
So, but sometimes, I do have clients that are 22 years old and they age out because the petition was pending for 2 months, for example. So oftentimes they compare themselves. My friend was 27 and they made it. I'm 22, I didn't make it. So it's just important to do proper calculation, subtract everything, see when the priority date became current. It's pretty complicated process. And oftentimes National Visa Center, even embassy makes mistakes. So I usually have to do recalculation to see if that's correct. So it's a really important mechanism.
Yes, I think it's very rampant here in the Silicon Valley also with the South Asian immigrants.
Yes. Yes, definitely. So, it's just important to review it, to understand it. Oftentimes I see mistakes and, that's problematic. But sometimes, unfortunately, when I want to point out, it's black and white. It's not gray. So the officer cannot decide, even though you're 21 years old and 5 months, I'm still going to grant the green card. It's just not possible. That's what most of my clients think. But unfortunately, it's not possible. It's very black and white calculation.
Well, thank you for shining the light on that. I think much needed. And so folks, if you are planning a temporary or a permanent international transfer, and if you're stuck in the CSPA mode, the NPZ Law Group, also known as Visa Serve, can help you. They've been serving a growing national and international community for decades, and they can help you too. So get that help at visaserve.com or just call them at 201-670-0006. We'll be back in a jiffy with more on what you need to know about immigration matters. Stay tuned. It's Mirchi and it's hot.